Probably
This
going to do
conference will now be recorded.
a Zoom call or GoToMeeting where you guys can give us questions in advance and probably give you guys some ability to interact on some of the questions as well. We'll answer them and try to keep them short and sweet, but there's a lot of things that are going on right now. One of them is what we're talking about today. There are eviction issues. There's small business loan issues or questions. Fortunately or unfortunately, we have a lot of experience with corporate structure, corporate restructuring, and bankruptcy. Not trying to scare anybody with the B word, but we have a lot of people that are actually asking about what type of protections they should be taking right now. So that's kind of why I prepared this presentation. But we're kind of in an unknown. I do try to be positive on everything, and I do believe, but it's just my opinion, nothing else. I'm not an economist, but I do believe this is going to pass. Just perspective, we've all been waiting for I don't know if I want to use recession or restart, but a restart or a reset of the commercial real estate industry. Is it going to come in 6 months, 12 months, 18 months? Well, we just got the mother of all catalysts that exacerbated it, and so it's here. And the worst of it may be in May, maybe. I anticipate it'll start looking better the end of May. And I'm trying to be positive on this because I really do think, it's affecting all of us, including myself and my team. And I have assets as well, just like you guys. There are some positives out there because I did do a quick poll on our Callister kind of news feed that we have on Facebook. It's a private group, and it looks like I would say about 75% of the people that responded today have collected between 40 and 50% of April's rent yesterday. So that's good. That's actually really encouraging. Our personal experiences, I think we're running like 1% above last month. We track KPIs. And so we actually look at the actual details. I don't need to look at it at that granular level. We do have I think we have about 3 or 4 tenants at one facility and I think 5 at another that said they're not going to be able to make their rent payments and are already asking about doing kind of a payment plan or a promise to pay, which is good. I assume all you guys are discussing with your tenants on a regular basis, hopefully not face to face. We actually, one of our buildings up in Lubbock, we have 3 tenants that supposedly have the coronavirus, and they've been asked to be quarantined. So it's in the smaller cities too, guys. It's kind of everywhere. They just don't have the same type of testing facility or capability there yet. So anyway, I'm gonna go ahead and start with the presentation. Just wanted to kind of give you guys some thoughts real quick. For those of you that don't know me, and I think everybody knows me, my name is Merrill Callister. I'm with Callister and Associates. We have a boutique law firm practice based out of Dallas. We represent mostly commercial real estate purchasers and help them on the real estate side as well as the syndication side. We represent them with the SEC, Blue Sky filings, PPMs. We also have a title company. As I mentioned to a few of you before, I do have an extensive corporate restructuring and bankruptcy, commercial bankruptcy experience that dates all the way back to 1999. From 99 to about 2008, I worked for initially a really large law firm that has since merged, I don't know how many times. But I had the wonderful pleasure of working on Enron and some company that you guys remember called Blockbuster, and Kmart's first or second Chapter 11, WorldCom, and then probably about 12 or 13 different oil and gas companies, mostly representing either the debtors or the secured creditors. But so when we talk about forbearance agreements and stress tests and stuff like that, just so you guys know, we're talking about insolvency issues. So that's where I'm going to start this off. I'm not saying anybody on this call is insolvent by any means. Nobody should be yet, or you have issues that that stem before the virus. So I'm going to make sure I can click this. There we go. So I try to be funny. You guys, some of you know I kind of joke around a little bit, but we have a lot of people out there on social media, that are chicken littles, just running around. The sky is falling. The sky is falling. Um, there are a couple different ways to look at it. If you truly think the sky is falling, I'm one of those people that believes you'll make the sky fall. I think that there are a lot of things that are being done. I'm pleasantly surprised about the collections of the people that responded today. It was awesome. I mean, it was good to see that without any government help, we still have a good base of tenants that want to pay their rent. So that was very encouraging. So try to stay away from the chicken littles. There are a lot of them on Facebook. Honestly, I've probably deleted about 27 different friends. Not really friends, but people that were supposed to be friends. They have no purpose out there. So this is my last kind of funny thing. So I would say Cindy and I and Greg, we view a lot of the people that are coming to us kind of like a deer stuck in
Hello?
headlights.
I can't hear anything. Is anyone speaking?
Jeff, can you hear me? Can everybody hear me?
Yes,
Okay, perfect.
working on it.
Okay, thank you.
Keep going.
So we view this like and a lot of you, and quite honestly, to an extent, so am I. This, we didn't have any warning for this. This just kind of came upon us 3 weeks ago, and it was like, maybe something's going to happen, and then we shut everything down. So the key here is don't be a deer in headlights where you see bright lights pointing right at you and you just freeze and do nothing. That's the worst thing you can do. Now, you should be patient. I'm going to go over three quick topics. Be informed, know your options, which is kind of the basis of this PowerPoint. I think I've probably ended most of my posts on social media with be patient. Everybody wants a quick fix right now. You have to be patient. The quick fix right now, they don't look pretty. So we're going to get into that, but part of it is being proactive, not reactive. If you react to every single thing you see, it's going to be bad. It's highly recommend, whether it's our firm or another firm, when looking at these issues, and we're going to talk about the first one, which is the stress test, that you do consult with a commercial business restructuring firm. I'm not telling you to go into bankruptcy, but there are a lot of things, if you're showing on a stress test, which we're going to go over in a minute, that you're going to be stressed. There are things you need to start doing now that prevent you from going to phase 3 or phase 4. Okay. So this is kind of what the PowerPoint's going to talk about real quick. Perform a stress test. And guys, it's a term of art. Stress test is basically a solvency test. Are you still solvent? At what point when you're performing a stress test does your economic vacancy drop to a point that you're no longer solvent? So that's all a stress test is. And then what happens after that? You could have capital call options. You could have an investor unsecured loan made. You could have a forbearance agreement. You could have a negotiation with certain vendors to possibly delay. There's some issues with that. You could look for a Chapter 11. You can look for a Chapter 7. Those go in order of best to worst. And so, like what I said at the beginning, I'm going to focus very little on the two worst, Chapter 11 and Chapter 7, because there's nobody on this call, and I don't even know everybody on the call, but there's nobody that's ready for a Chapter 11, Chapter 7 yet. So again, okay, I had one more slide that was stupid. Stress test. It's not this type of stress test, though. I think many of us right now should probably go get this type of stress test because we're all feeling it. It's really just the unknown. If we knew what was going on, we'd be a lot less stressed. But it's this type of stress test. So basically you're looking at, and I go into a little more detail than I need to go into on a PowerPoint presentation. You guys are all going to get a copy of this. Those of you that may have listened to James Ng did a really nice presentation on stress tests and forbearance agreements. So I asked him if I could use his template, modified a little bit, but it's not that complicated. You're looking at your cash flow, income coming in, expenses going out. And so you have a pre-COVID-19 protocol protocols, which means February and January, you had X amount of income coming in, then X amount of expenses going out. And so presumably we were all cash flow positive, presumably. Now the question is, and we're going to find out most likely in May as opposed to April, but can we survive with a 20% economic vacancy, or a 30% economic vacancy, or 40 or 50? And if we can, how long can we survive? So survive simply means it's a solvency test. It simply means that so long as you're able to make your bills in the ordinary course, you're able to pay the bills, and the lenders obviously are worried more about the mortgage, then you're solvent. You've satisfied the stress test. When your cash flow goes to negative, you presumably have an OPEX account, a reserve. If you don't, you should have, but you presumably have some sort of operating expense reserve account. So as you go negative on cash flow in a month, if you do, you have some cash sitting in that account to use for that OPEX negative. So the idea is presumably in April, May, and June, we're going to have, some of us may have negative cash flow. Okay. How long can we survive that negative cash flow? What can we be doing to decrease the negative cash flow? What expenses aren't necessary right now that would decrease cash flow? That's a whole property management issue. I've done a webinar on that recently too, because we do property management as well, oversee it on our assets. But you can't increase the income right now. There's no question about it. We can't increase the income. So the only thing we can do is try to decrease the expense and comfort our tenants, not physically, but 6 feet apart or through email or social media. But remember, most of our tenants, I would say 90, 95% are good people, and they didn't ask for a layoff. And quite honestly, they want to go back to work. They truly want to go back to work. So this is really just a temporary blip. And you guys have to please keep in mind, this is temporary. Will it go back to the way it was before? I don't know, but it sure as hell will be better than it is right now. That I do know. So we have this slide right here. Again, you'll have a copy of the PowerPoint. It's nothing that exciting and it shouldn't shock you, but basically we have income projection, expense projection, and then I show January, February, March. This is just a made up thing. I'm showing monthly income at 150 a month, and then I show a 40% economic vacancy starting in April. That to me is a worst case scenario based on what I've been reading. So that means my income drops to 90 grand. And I try to be very conservative. I'm showing my monthly expenses, January, February were 91,000. I don't show anything decreasing on monthly expenses. I want to know worst case scenario. So that shows me at a negative NOI of $1,000. That doesn't sound bad, except you have this little thing called a mortgage payment. And depending whether it's a new loan that's interest only or a loan that's seasoned, that's got principal and interest, you've got that mortgage payment. In this scenario, the mortgage payment's $34,500 a month. So I'm looking under April. So in that scenario, you have a cash flow loss or shortfall of $35,500. You can see at the very bottom, your cash on hand in March was $199. Your cash on hand at the end of April is $163. So by looking at this scenario, it's just a scenario. You can show that for April, May, and June at a 40% economic vacancy, all other things staying the same, and then slowly creeping up as I would assume the protocols wear off. They may wear off before then, but being very conservative, this scenario, they survive the stress test. Now, you can put in 50% to see what that looks like. There's lots of different things you can do. What I would implore you people to do, everybody to do, is that stress test needs to be analyzed every 2 weeks. This is not I'm doing a stress test today and not looking at it again, because you will be on that treadmill in the picture before, getting your own stress test because you're gonna have a heart attack. So you need to be evaluating the stress test, I would say April 15th. Most of us, a majority of our rent payments have come in. We all have some that are late pay or have different things worked out with management companies, but the bulk, I would say 75, 85% of your rent is probably coming in by April 15th. You do another stress test, and then you keep forecasting out. You want to make sure that you're constantly aware of what's going on. And I would also suggest that as you're doing these stress tests, you be transparent with your investors. okay? That's going to be key a little bit later on. What I'm going to talk about is be transparent with the investors. Show them what you're doing. Show them how collections look for the month, okay? Nothing is worse than not being transparent with the investors. So you want to show them what you're doing. You want to show them how it looks for the month, and you want to show them what you're forecasting based to the best of your knowledge. Okay, well, that's kind of, I skipped ahead. Be transparent, communicate with investors. That should be obvious to everybody. My 20 plus years of a lot of corporate litigation, very few lawsuits were caused by people that over communicated and were too transparent with the other side. Okay, it's the unknown, just like we all have unknown right now that's stressing us out. That causes people to do things reactively instead of proactively, and it's not good. So I really want to stress
Meryl, you muted yourself.
Am I back on? Okay, I don't know
Yeah,
where I
Go
unmuted.
back on.
Okay,
Go back on.
thank you. So anyway, so just make sure you're transparent and you're communicating. So next slide. All right, this is something, this is like the evil. Nobody likes to talk about this. These are, let's see if I can move this down so I can actually read this. Capital call provisions, okay? Everybody's got a company agreement or a partnership agreement if you have an LP. And in that agreement, you either have what are called discretionary capital call provisions, meaning you can't be forced to make them, but the manager has the ability to request capital call. And then you have mandatory capital call provisions, where if the manager decides to make a capital call, everybody has to contribute. If you don't, depending on your company agreement, your LP agreement, you might be diluted a little bit because others have a higher dollar per unit. There may be some other issues with it as well, but you have one of two provisions. I would say the majority, probably 70% of all of the syndications we work on are discretionary. I can read this provision to you, but it's almost irrelevant what it actually says. It's simply know that there's a discretionary capital call provision and a mandatory capital call provision. And typically it's around, Cindy could probably correct me, but I think it's around Article 3 in most company agreements. And it's pretty funny. You'll see mandatory capital call, they're pretty self-explanatory. There's not a whole lot to it. If at any time additional capital call contributions are required pursuant to this particular section, then the managers, hold on, I can't read what I'm doing here, may make a written call on the members to make additional capital. Okay, so that is an option of every investor. So in a typical deal, and depending on, some of you are with certain real estate groups, capital calls are no-nos. You don't do a capital call. I'm coming at this from clearly a corporate restructuring, pre-bankruptcy lawyer, not as an investor like you guys. When it comes to market conditions that we're seeing right now, where, you know, I would say half the country is not working, that was never anticipated by any of us. Even with all of the risks that we build into the PPMs, I guess we have to start now building in COVID-19 shutdown of the entire world as a risk. I would not let the fact that you need to make a capital call dissuade you from doing the capital call. And I'm going to get to it right here. Okay, so when it comes to capital calls, it doesn't necessarily have to be in this order. This is the way I perceive from a corporate restructure standpoint. I would rather you go to the investors and pool money together, because it's a lot smaller piece per investor than to have an investor or a manager or an outside source make an unsecured loan to the company. I'm going to get to that in a second. So whether you're mandatory or discretionary, and you see in the stress test that you're going to go negative, you need to make a capital call before you go negative, okay? So if you see in June, based on your updating your stress test every 2 weeks, that you're probably going to go negative, you decide to make that capital call in May. I can promise you, as an investor and as a syndicator, I would much rather put an extra 5 or 10 grand or whatever the number is to avoid losing 100 grand or 200 grand, knowing that eventually people are going back to work. That's my opinion. That's also kind of what you want to do with respect to loading up your capital stack on your fund. You'd rather have equity first than putting a loan on the property. So when you estimate your negative cash flow, let's say June, July, and August, you're estimating you're going to be negative a total of 50 grand. This is me being very conservative and a lot of experience with other companies that were threatening insolvency. You want to make a capital call that's 2.5 to 3 times the amount you think you're going to be negative on. Okay, that may sound a little harsh. My gut tells me, and especially in this economy, you're only going to have one chance to make a capital call with your investors. You cannot go back to them 2 and 3 times. That's not going to bode well. So the nice thing is, if you make a capital call for, let's say you were forecasting $100,000 shortfall and you raise 250 or 300 grand, and in September you're back where you should be, distribute the capital back. No one is going to complain that you distribute the capital back. I guarantee you. If they do, you didn't want them as an investor in the first place. No one's going to complain about getting their capital back. And then again, I kind of spread the number over investors. If you have 20 investors, you need $100,000 or even $200,000. It's 10 grand an investor. Doesn't mean everybody's going to invest, but my recommendation is, if you see that in your stress test you're going to go red based on it being updated, you need to make the decision very quickly to make a capital call. Why capital call? Most logical next step. Does not put another creditor ahead of investors that gets paid first. So that's important, because if you do a loan first, and we all have provisions, I would say 99% of the people on this call that are syndicators or investors, there are provisions in your company agreement, your limited partnership agreement, that allow for a member or manager to make a loan to the company. Okay, and so that is allowable, and it's up to the manager's discretion in most of the agreements to make a loan to the company. The issue is going to be whoever makes that loan, in theory, is putting themselves ahead of the equity. Okay, they're going to get paid first. They're going to get a preferential payment, an interest rate, a preferred return, unless it's structured otherwise. But from a bankruptcy related perspective, they don't want it structured any other way. They want it structured as they get paid first, from their perspective. I would be very careful about doing a loan. It's the next slide. You got to make sure, number one, your loan documents allow for it. Okay, you're not going to be able to make a secured loan. You make a secured loan, you're going to get into big trouble, especially the market the way it is right now. So it's going to be an unsecured loan. So it's going to be a friendly, an investor, or a manager. No one else is going to make an unsecured loan to a failing business, right? So be careful. You need to have a lawyer, somebody go through, read your loan docs to make sure that it's not breaching your loan docs. The reality, though, is if a bank gets wind of it, and I'm not sure how they would, because it's not a secured loan, so nothing will be filed, but if they do, if they become aware of it, I don't know how many banks are actually going to exercise their rights to foreclose on a multifamily right now when you have an investor or a manager that is infusing cash in there and preserving that secured lender's collateral. Does not make sense for a bank to foreclose or use its due on sale provisions for that. So I don't foresee that happening, but you just need to be aware of everything that's going on. There's not going to be any collateral or security for the loan. So if anybody on this call is thinking about making a loan, it is an unsecured loan. You're stepping behind the creditor. And then you can negotiate terms. It's just going to depend on what is, as a manager, what's in the best interest, not for the investor. And if you're the manager making the loan, it's still what's in the best interest of your investors. You have a fiduciary duty to your investors. So you can't say, oh, I want to charge myself 14% because no one else will loan. It's still got to be what is the best decision for the investors as a whole. So you need to keep that in mind. Okay, so this one's fun. based on the picture, you guys can probably see what I think of forbearance agreements. Kind of self-explanatory. I could just stop right here. So there's a lot of talk about forbearance agreements, and to my knowledge, I haven't actually had a client send us an actual agreement, though we've been sent terms, kind of generic terms. I used to refer to them, and I had a partner I used to work with a long time ago. A lot of forbearance agreements are like sinkhole agreements or like quicksand agreements. Once you get in, it's very hard to get out. And as you can see from this picture, there's no end to the bottom. And so I put forbearance agreements behind capital calls and behind capital going into a deal as a loan because they're very draconian in nature. If you define forbearance, it's the action of refraining from exercising a legal right, especially enforcing the payment of a debt. So remember, it's the lender that is forbearing from foreclosing on you, okay? The lender is the one who's in complete control on this deal. You've come to the lender and you said, hey, lender, I'm insolvent. That's your first issue. You've just told the lender that if you don't get a forbearance, you're going to breach the loan docs. Okay, so you've just declared that you either are insolvent or you will be insolvent. So you have to keep that in mind. Number two, the lender is going to have some provisions, at least right now. I think the lender's provisions are going to ease up in about 3 or 4 weeks, assuming that economic occupancies drop. Maybe they won't. But right now, the forbearance terms and the ones I've seen are Fannie and Freddie are very harsh in nature. Everything comes with strings attached to it. Keep in mind, once you go to a forbearance agreement, your next step is bankruptcy. There's nothing else you can do outside of forbearance. Your loan, for the most part, you won't be in a position to refinance. Because if you're in a forbearance agreement and they're looking at the value of your asset based on cap rate, presumably your income has dropped, so your valuation has dropped based on cap rate. And if anybody wants to give you a loan and take out the Fannie or Freddie loan, if it were even possible, they're not going to come in at a better rate than what you have now. And if you're not able to pay the rate you have now, it's the kiss of death. So if you can't survive the forbearance agreement, you're going to have to file Chapter 11. If you don't file Chapter 11, the bank takes the property back. 100% of the equity is wiped out. So that means if you raise 25, 30% of the purchase price and rehab as capital, all that capital will get wiped out in a foreclosure. It's gone. So, I'm not trying to scare people, but I want people to understand that there are consequences. There are good consequences and bad consequences, but there are consequences in the decisions you guys make, and I'm trying to lay it out. Normally this would be a consultation that we would get paid pretty good money for in the old days, but lay out kind of what your options are today. And I'm telling most people today, don't exercise any of the options. Try to be a little patient. It's only April 2nd, but you need to be thinking about these things because the lenders are throwing a lot of forbearance terms out there. So this is just kind of generally, the lender is not patient. The lenders are scared right now. They came out with initial FH's forbearance agreement terms prior to borrowers requesting them. Don't you guys find that a little odd that Fannie and Freddie came out with forbearance terms before anybody actually asked them about them? So they already are, they're trying to prepare themselves for what's coming or what could be coming. And the first phase of this is going to be the harshest terms you've ever seen, okay? Because they don't know if it's going to be that bad, but they know you're scared and you may be more scared than they are. So when they become scared, if they become scared like 2008, 2009, you're going to see some very, I don't know if I want to use the word friendly forbearance agreements, but a lot less restrictive, okay? But it's only April 2nd, guys. And so they're not going to be favorable terms to your benefit. They're not sympathetic towards you. Remember, the lender is not your friend. The lender is about making money just like we are. So they're not going to be sympathetic to you. The lender has their own investors, okay? B of A, Wells, Chase, all of the Freddie and Fannie back loans, they all have investors. If those investors don't get their coupon, or their dividend each quarter, each month, that some of those investors can make margin calls. There's all sorts of things they could do that would tank a lot of these lenders. So they're very scared, but they think you're more scared than they are. It's kind of a game, unfortunately. But the idea right now is this is what they're first coming out with. This is their first stab. It will change. I can't guarantee you, but I feel about 95% positive the terms will get better, not worse. They can't get worse. And just to keep in mind, even if you have to go the forbearance agreement route, you guys, this is more from a personal thing. You haven't done anything wrong. Okay. You haven't done anything wrong. There are circumstances beyond anybody's wildest imagination that are occurring right now, and that are happening so fast that it could have never been foreseen. So the pros of a forbearance agreement, it buys you time. Not a whole lot. The first terms that we're seeing are 3-month forbearance agreements. Guys, that's not a lot of time. So technically gives you some breathing room. It could allow you to prioritize some cash, and it temporarily prevents your lender from putting you in a default. However, I would read your loan documents and your forbearance agreement very carefully to see if you actually are in a default or they hide some provisions in there. Okay, because if once you go into a forbearance agreement, you release the lender of any lender liability, okay, which is a big deal. That could be a nice cause of action later if it looks like, for example, the lender not allowing you to evict tenants for a period of, in some cases, 15 months, caused you to have to file bankruptcy. That would be a claim against the lender. But you're waiving those claims right now. You have 0 claims against the lender with these draconian provisions. So strongly encourage you to, again, speak with a seasoned lawyer law firm that's familiar with restructuring and familiar with kind of pre-bankruptcy workouts, because there's going to be some gotcha language in these. So I want to just caution you guys, try not to sign anything yet. Cons, this is where I go Debbie Downer. You've put your lender on notice you're about to default, okay? I don't care what anybody thinks. If you go to your lender, you go to Fannie right now, or you go to Doherty, and you say, hey, I need to talk to you about a forbearance agreement. You have just notified them that you're about to go into default. Okay, I'm not trying to scare anybody. You've just done that. So be careful. Think about what you're doing, okay? You haven't actually gone into default yet, but you're noticing them that you think you're about to. That changes their whole attitude. Depending on your loan docs right now, and also depending on the forbearance agreements that are being drafted right now, there are most likely going to be cash collateral mechanics that are triggered either by the loan documents that you originally had or by these agreements, which means they control the cash coming in. Okay, they have sweep accounts, they have lockbox accounts that they'll set up. They're probably in, I would say, 70 or 80% of most of the agreements, most of the loan docs that we review. They're under the default provisions and the remedy section. So they're going to have sweep accounts and lockbox accounts. You know why? Because they don't care about you. They care about getting their mortgage paid. And so first cash in is the first cash out to go pay their mortgage. So expect to see that if you're doing a forbearance agreement. Heavy restrictions on what you can or cannot do. I'm gonna get to that on the next slide. And I told you guys initially, it is the last step before foreclosure and bankruptcy. Does not mean you're going into a foreclosure or bankruptcy, but it's your last option at that point. Okay, so I want people to really think about this because we're getting a lot of calls about forbearance agreements, and I don't think people understand the ramifications of them. The lenders sound real friendly right now, but they're not. They don't have any pressure on them yet. You know, will you have potential or probable business credit issues in the future? Possibly. I think on one of the next slides, we discuss, or I mention whether you go into their special servicing category. It's like going to solitary confinement if you're in prison. So I'm told. You don't want to be in special servicing. Those are people that are in default or about to be in default. And so they claim right now you're not. I promise you, you're already on their radar. So I'm going to update you guys. This is the latest. I don't think it's changed much. This is about a day old. Freddie Mac forbearance agreement terms. So those of you that have Freddie Mac loans, if you look at a forbearance agreement, you should expect to see these things in it. Number one, you must show hardship as a consequence of the COVID-19, basically the protocols or the effects. Hardship, Okay, guys, hardship to the bank means you can't pay their mortgage. Again, you're telling the bank that you're about to be insolvent or you're insolvent today. If you're sitting on $300,000 or $400,000 in capex, in cash in a reserve account that you could use to pay the mortgage, you are not going to get a forbearance agreement. Okay, so don't expect that just because you ask for one, you're going to get one. You guys need to keep in mind, this goes back to the stress test. They're going to want to see a stress test. They're going to see financials, and they're going to take over your, most likely your cash accounts. Right now, the forbearance period is up to 90 days. And I'm a lawyer, so I'm always going to underline words that are kind of gotchas. No one is guaranteed a 90-day forbearance in a forbearance agreement. They're giving up to 90 days based on your hardship, okay? So these are the terms today. Your monthly principal and interest and reserves. Many of these have OPEX reserves requirements. Your loan docs, they're postponed during the forbearance agreement. So during the 90 days, you don't have to pay your principal, your interest, your tax escrow, your insurance, any other type of reserve. Okay, that's postponed for the first 90 days. They will not, this is according to Freddie, you will not be assessed late charges and your default interest is waived. This is tricky, guys. Default interest is waived. I haven't seen anywhere where it says default is waived. Okay, and just because they waive default interest doesn't mean that you're not in default. Okay, you need to really be aware of what happens when you sign a forbearance agreement. Under Freddie, you cannot evict a tenant based solely on no payment of rent from COVID-19. You can evict a tenant for something else, subject to, here's where it gets fun, subject to your city, county, and state restrictions on evictions. And then the newest one is subject to the 120-day restriction on any federally insured loan. So it's complicated. But under Freddie, at least under the forbearance agreement, which then has to be looked at with the other restrictions that may trump it, you know, you're still supposedly allowed to exercise an eviction. However, like if you live in Dallas, the courts are not open, so it doesn't really matter. Now, if it's non-payment of rent for COVID-19, it's not even evict. You can't even file a notice of eviction. Even though the courts aren't going to be open, you can't do that, period. Again, you have to release claims against the lender for any adverse effects related to the eviction restriction. This is going to come into play under Fannie's restrictions more than Freddie's, excuse me. You're required to repay missed payments over a 12-month period. So your mortgage payment, let's say your mortgage payment is, in that example, I think it was like $35,000 or $34,500. So you can forbear 3 months worth of mortgage payments at call it $35,000. So that's $105,000. Now you have to make that $105,000 payment over the following 12 months. Okay, so you're going to have to make a payment of another, $9,500 plus or minus on top of what you're already paying. So you're going to pay a $44,500 mortgage payment. You need to run your stress test before you sign this and see if that's even plausible. Okay, knowing that during that first 3 months you can't evict anybody, so you may run into more people that are not paying rent and that are decreasing your economic occupancy. And then the loan will not be transferred, typo right there, I apologize, will not be transferred to a special servicer during forbearance. That is a plus. Once you go to special servicer, you're screwed. It's very hard to come out of that. That's kind of they call them their problem loans. My guess right now, the reason it's not transferred to a special servicer, they have no way to handle all these loans coming at them at once. It's impossible. I saw a number where there are 20,000 multifamily buildings that are being financed by Freddie right now. No way, multifamily apartment complexes. And then Freddie and Fannie, these are non-negotiable. It's a document, there's no negotiating, you just better understand the terms. Now, Fannie, I'm gonna go through this quickly because Fannie is basically the same thing, except I wanna focus on number 2, okay? the forbearance period. So this is when I say forbearance, I'm referring to in this slide the forbearance of evicting a tenant. Okay, so under Fannie right now, the forbearance period is the longer of 90 days after the effective date of forbearance, which is a 90-day forbearance on payment, or until the loan is brought current. So remember, you have 12 months after the 90 days to bring the loan current. So you could be effectively barred from evicting a tenant who lost his or her job or claims another issue under COVID-19 for 15 months. Okay, you guys have to think about that. I told you earlier, you're gonna have to make a payment of almost $10,000 more a month during those following 12 months. And you have, under this scenario, you have potentially tenants that don't have to pay, you know, if it's 12-month lease for 12 months. How are you going to get the extra income to cover the extra $9,500 in that scenario? So it's very important that you read the terms of your forbearance agreements if you want to go into the forbearance agreement. So again, monthly P&I and reserves, they're postponed. Interest and default charges waived, but default is not waived. Same thing, cannot evict a tenant solely based on non-payment. That's very broad, guys. I just want you to understand it's very broad. And the courts are going to be in favor of the tenant right now. No question about it. So you got to have a tenant doing something really bad to not be able to prevent you from filing an eviction, assuming that you're allowed to under state and federal law. You release the claims against the investor. Let's see, and that's the same thing, non-negotiable transfer. So Fannie is a little different. So Fannie gives you an LOI. You get basically an LOI, but not like the LOIs we're used to as syndicators. This LOI means here is what we're going to agree to, and you can't respond to it, and it is binding. They call it a pre-negotiation letter. It's an LOI saying your document is coming. You've got 48 hours to look this over with your lawyer, but this is what your document is going to say. I just put they could be draconian, handcuffing terms. I just summarized the sweep accounts, possibly waive all notices of default. Okay, so now we're coming towards the area where I don't think anybody is ready to go into yet, but I'm just going to touch them very briefly. We're getting close to the end of the presentation, so we can open up for questions. But negotiating with vendors. So you've tried to raise capital through a capital call. It either worked or didn't work, or you skipped and went straight to a forbearance agreement, and or you took a loan through an unsecured loan with an investor or a manager of the fund, and that didn't cover it. And now you're either in a forbearance agreement or you're looking like you can't make your monthly payments during the 12 months you have to pay it back. You want to start talking to your vendors, and you want to conserve as much cash as possible. This is the point where you contact a restructuring or bankruptcy lawyer with respect to this, because there's something, I don't want to get too technical on the legalities, but once you've put Fannie or Freddie or any lender on notice that you could be insolvent in a month, or that you are insolvent through a stress test, different payments and different transfers of cash become very crucial. If you decide not to pay your utility for 90 days, but you pay, not to pay your gas for 90 days, but you pay, you know, your electric, which you really need, you kind of prepay them to make sure they're covered for the next 2 months. Ultimately, the court's going to unwind that transaction, and it's going to hurt you. If you try to move cash around to avoid creditors being able to get to that cash while you're deemed insolvent, that becomes an issue. On the fraudulent transfers, it depends. I think you can go back 2 years on fraudulent transfers. Nobody on the call that I'm aware of would even remotely have that issue. But on the preferential transfers, if you haven't notified somebody you're in bankruptcy or you're insolvent, the court looks at 90 days before you actually filed. So even if you didn't notify somebody, they deem you insolvent 90 days before you actually had to go file for bankruptcy. So there is a premise that you were already insolvent. And when you're negotiating with creditors or vendors, you got to go back and look at your forbearance agreement. You got to look at your forbearance agreement and your loan docs. You can't prefer any vendors over your secured creditor. It's going to get you in big trouble. this is just going to take a second. So we have Chapter 11. Chapter 11 is a restructure. I look at when I used to advise people, Chapter 11 is a court approved refinance. Okay, totally different than Chapter 7. Chapter 7 is a liquidation. Your investors will be wiped out, no question about it. They'll sell the building. Suppose it'll be a fair value price, but it's going to be sold at the courthouse, the federal bankruptcy courthouse, typically through some sort of silent auction or some other process where you have a stalking horse that comes up and makes the first bid on the property. But Chapter 11 will allow people to come in, or lenders to come in, that might be white knights or stalking horses or whatever that could provide favorable terms. And in this situation, Fannie or Freddie might be willing to allow those loans to be refinanced. You also have situations where a federal bankruptcy judge and the creditors committee could convince the lender that you have, Freddie, Fannie, whomever, to do a better forbearance agreement than what you did pre-bankruptcy, because the bankruptcy court will actually put them ahead of everybody else, knowing they have the security. So a lot of people, I shouldn't say people, a lot of companies have come out of Chapter 11 in a much better position that continued to thrive. Chapter 7, you don't want to talk about it. Last case scenario, it's I'm done. I'm assuming I'm never going to do this again, quite honestly. Not me, but I'm assuming as a syndicator, I'm done with these deals. Because once you lose all your investors' money, it's going to be very hard to raise capital again. But that's just a free-for-all. Typically, it's going to be sold for what the lender has in the deal, possibly more if there's anything else left over above the lien amount. That will get dispersed amongst creditors first, and equity is last in line. And I haven't seen a single Chapter 7. Well, I can't recall a Chapter 7 where equity got a whole lot, if anything, after creditors were paid. So again, just recapping, can't tell you guys enough, stress test, insolvency test, stress test, cover your ass test. You can call it whatever you want. You've got to project. It's a very simple budget: income versus expenses, then take out your debt service. How long can you go? And look at your numbers again, April 15th, April 16th, a little bit after the middle of the month. See how your cash receipts are, and maybe take that number. If you're going to take that number from April 15th or 16th, or you can go to the end of the month. And then I would probably, if things haven't changed, and I don't have a crystal ball, if things haven't changed, I might decrease my economic, I might increase my economic vacancy by another 10 or 15% for May, just in case, and then assume it'll start evening out June, July, August, hopefully. Very, very important. Got to communicate with your investors when you're doing that. The reason you want to communicate, because when it is time for a capital call, your investors are not shocked. No one's shocked. No one's like, oh, you never told me, and oh, for 120 days everything was going great, now you want capital from us. So much easier to go raise capital when your investors are sitting there and they're well aware of what's going on, and they also know you're not alone. It's not you that did it. You're not alone. So I prefer capital call as the second option. Some people prefer investor unsecured loans as the second option. It depends on their perception of how their investors will look at them. That's a business decision. They're pretty equal in my mind. Forbearance agreements, when you get to that point, they're tough. They're going to be tough, guys. You need to have a lawyer look at it. Obviously, you're working with your mortgage broker. But you need to have a lawyer look at it, and have to look at it in conjunction with your loan docs. You need to be very careful. Negotiating with the vendors, last case resort, you never want to do that without a lawyer, period. And then Chapter 11, Chapter 7. So Rob made some funky little sanitary wipes, but we're not giving them away because we're out of them. That's right next to the toilet paper we don't have. But for those of you that want to talk to us, talk meaning a Zoom, or even email us about what we talked about. We are doing free consults for anybody that wants to. Been doing them for the last week. You can use your phone, and you can actually scan in your viewfinder the little box right there. Or I believe Jeff will send out copy the presentation tomorrow to everybody, and our information is right there on the last page, but I'll leave this up for a minute. And then we're going to open it up. I don't know if there are any questions. Jeff, I see 37 comments. There might be some questions. Jeff, Cindy, whoever.
Yep. Can you hear me?
I can.
Okay, good. So there's been several questions about whether capital call or idle would be better. Would an idle at 4% be better than a capital call, assuming the lender allows it?
Okay, so it's funny. Idle. This is my knowledge, and guys, I am not an expert on the latest SBA loans. Okay, I'm not an expert. I'm learning just like you guys are. I read a lot, but I'm learning. I don't know that an idle can be utilized for a fund, a syndication fund like we have, if you don't have employees that are paid salaries. I'm not saying it can't be. I don't know if you're going to get approved for it. So number one, idles, here's the thing. So idles, as opposed to forbearance agreements, you're going to be personally liable for all the debt. Personally, they're going to secure your house. They're going to secure all your assets. You'll be personally liable. Forbearance agreement, you will not be personally liable, to my knowledge. I haven't seen the final details in it, but I haven't seen that as one of the provisions. So if I were to choose which one, I don't believe you're going to be first in line as a business because you don't have employees. Some of you do have employees. That's totally different. You may have a property management company that you manage through. So that will obviously help your property management company, but the government is not bailing out investors right now. So I don't see that as being approved. I mean, the reality is this third segment of aid that came through, it's been defined up in DC as the employee-employer fund, not the investor fund and not the lender fund. We all believe that's coming in round 4, but they have to actually start round 3, which starts tomorrow, and get that going. So I can't guarantee it, but I don't see, and I had an hour-and-a-half conversation with my CPA firm. Some of you guys use Savile & Associates. We did not see that as an option for our fund. Our fund doesn't need it right now, but I can see where some funds need it. We did not see that as an option for our fund. Now, it is a very viable option if you have your own business. And if your business is property management or construction or something like that, and you're making payroll and you're paying payroll, it's an option. I don't know if Jen's on the line or not. She's our controller, but Jen and I went over these numbers this morning, and you have to prove that you need it. You're going to have to go back, and you're going to have to show that you're in need of it, and you're going to have to. I think people are going to waste their time trying to do that for a fund, personally.
Okay. Let's see. Yeah. Another question is, if you file for bankruptcy, more than likely, would that invoke the bad boy provisions of your loan?
No, actually, no, because bad boy provision, well, it depends on what they say. Listen, if you had to file for bankruptcy, at that point, you've already been talking to your lender. Your lender will already know. The reality is most of these type of transactions, these syndications, will never get to a bankruptcy. The lender doesn't want it to go to a bankruptcy. You're going to threaten to file bankruptcy if the lender pisses you off. So remember, the lender cannot put you in bankruptcy. It's impossible. A secured creditor cannot force you into bankruptcy. Their only remedy is to force you into a foreclosure if you don't make their payments. They can't put you into bankruptcy. They don't want to be in bankruptcy because once you file for bankruptcy, all the lawyers, this is where I toot my horn, jump in, and we get lots of fees. And the fees come out of the estate. And the estate is whatever has cash value. And quite honestly, the only thing that has cash value is the asset and the cash accounts. And the lender wants that money for them. They don't want it to be paid out in professionals and hiring a trustee. who gets 15 or 20% of all recovered cash. So the lender is very, very, very disincentivized to want you to go through bankruptcy. You will have already been talking to the lender and trying to do a workout. That's a different type of forbearance agreement. That's a forbearance agreement that gives you much more favorable terms, but you got to be prepared to go there, because once you go to that level, you can't come back. So if you're going to threaten with it, you gotta make good on your threat.
Another question, comment on the EIDL. I thought the first 10,000 of the EIDL was a forgiven loan if you use the money for payroll, mortgage, and utilities.
Yeah, so the first 10,000 is a grant. First 10,000 is a grant, and again, the key word was payroll. So I don't know who's out there trying to get a loan for this that doesn't have an operating company. Totally different from saying I have an operating agreement for my LLC. A lot of our investors are LLCs that third party out the services. And listen, we've tried to make arguments. I've looked at arguments. Well, under my management agreement, I cover the payroll of my manager and my assistant manager. Well, that's true, but I don't actually pay them. I'm paying the management company, who I don't have an ownership interest, and they're actually paying the payroll. My fees to the management company are whatever 3 or 4% of revenue, plus covering their payroll. So it would be nice if the management company applied for that and gave us a discount. I think that's about as likelihood as it's snowing tomorrow, but that's the only way that's going to happen. Again, I don't see EIDL being a viable option. The $10,000 grant, you might be able to just, I think the government's just going to throw everybody a $10,000 grant that applies if it passes the smell test. But keep in mind, it is designed for employees and employers only.
Okay. Next, how does this change your underwriting on new transactions moving forward? More equity into the deal, longer term hold periods, etc.
That's a good question. That's a webinar I did yesterday for an hour. So listen, Cindy and I can give you our experience from what our clients are doing, and then we have our own personal experience, what we look at. Okay, so this is going to be my opinion only. This is the business aspect of it. As a bankruptcy lawyer, I've told people before, 50% of what we did as bankruptcy lawyers was business advice, and 50% was law. That was the only fun part about representing people, representing clients. We actually got to help them with business decisions. Cindy, repeat the question again.
Sure.
I was looking at
how does this change your underwriting on new transactions moving forward? More equity into the deal?
Yeah. So underwriting, a lot of you guys, you can actually request when you if you click on the link or scan into your phone, you can request information. So one of the things we've been doing for clients, and I think I made it public, a version of it. First of all, in the LOI is having a COVID-19 provision that basically CYAs you, cover your rear end, in case they're unknowns. But as far as underwriting, I don't think I would be underwriting any type of rental gain over the next 9 months. It's possible. Now, if you're underwriting based on a T3 in May, you better be underwriting an increase in revenue on the seller's T3. If not, you shouldn't be doing the deal, or you're getting it at such a price it makes sense to do the deal. But I would be making sure that my closing date was out at least 90 days. If I had the option, out 90 days. Lender terms today mean nothing, absolutely nothing. Everybody's trying. I don't care if they're quoting you 3.7, 3.6, blah, blah, blah. It means nothing. You can't lock in on a deal until a week or so before, and the terms are going to be different. I guarantee they're going to be different. Are they going to be better or worse? I don't know, but they mean nothing today. So from our perspective, what we see some of our clients doing that are still looking at assets, they're looking at more like 60 to 70% loan to value, loan to cost. They're going to get a little better terms with Fannie right now. And the argument is when the markets stabilize, whatever that stabilization will look like, you know, there may be opportunity to do a supplemental loan much sooner if you want the deal. I would negotiate right now with sellers. I think sellers are just as scared, if not more, than buyers. There are a ton of sellers out there right now that are on 3-year bridge loans that got really excited about what happened 2-3 years ago because they saw the market just, my dog, they saw the market just exploding. And so, you know, we're going to buy it, we're going to fix it up a little bit, fix up 33% of it, not worry too much about asset management because we're going to let cap rate, you know, rule the day. Okay, so we all know what's going to happen with those type of deals. The cap rate is not going to look very good. It's going to go way up, and they're going to not be in a position to refinance right now. So there are going to be some opportunities, and I would say there are going to be some opportunities very, very quickly. We just saw one. It's Oklahoma City. I'm not a huge fan of Oklahoma City, but the opportunity depends on where it is. We just saw one. The deal fell through. Buyer freaked out, and at a $37,000 unit door, it's a C- type place, but there's the possibility that the seller might take 29 a door because the seller can't get refinancing and the seller's out of options. So when you're underwriting, it's the same thing. Your pro forma is your stress test. We use this terminology. Your pro forma is your stress test. What do I need to make to cover debt service and expenses? And so if I'm going to have a lower economic occupancy, I better have a much lower price. And guys, it's fine to be told no. No is not a bad word. You do what you want to do, and you don't care about what someone else thinks it should or shouldn't do. You stick to your numbers. You know, everybody's got their own opinion, but at the end of the day, you know where your stress test level is, and you've got to stick with those numbers. Cindy, next question.
Got it. Let's see, will portfolio lenders who have put clauses into the loan docs that the borrower can't file for bankruptcy be able to stop the borrower from filing for bankruptcy? Sounds like a bankruptcy is a better way to go than a forbearance.
No, bankruptcy is not a better way to go. But even though there are provisions in there, there are certain cases where those provisions are unenforceable. In other words, preventing a debtor from filing bankruptcy. I still, listen, you don't want to really be in bankruptcy, especially not right now because most of the courts are still closed. So it doesn't really help you out right now. I still think going in the order of how I set it out, forbearance would be your kind of last option before you had to go to a bankruptcy or we call it a workout. It could be like a prepackage where you already agree with the lender after the forbearance doesn't work to kind of restructure and resize the debt and get rid of maybe a bunch of unsecured creditors that started to build up. And so then you put that through a very quick Chapter 11 where everything's been approved, so it minimizes your cost, and you're still working with the lender. Now, the reality is you're going to have a bankruptcy on your record. But guys, it's like 2008 through 2009, 2010. There are lots of people, many on this call, who had serious financial trouble in 2008, 2009, 2010, and are extremely successful right now. And it was not nearly the hindrance that people thought it would be. Maybe they paid a little extra in interest on loans, or they partnered with other people that had better credit. But it was understandable what happened in 2008, 2009, though there was a lot of, I would say, fraud that was going on. This has nothing to do with it. This is a factor that is nobody's fault except, depending on who you listen to, maybe another country's fault. But it's nobody's fault who's in real estate right now. Cindy?
This is really a public service announcement. Chase Bank just announced in the last hour that for the SBA Paycheck Protection Program, in quotes, Chase will most likely not be able to start accepting applications on Friday, April 3rd, as we had hoped.
So is that my friend Kevin?
No, it's
Okay.
not. Yeah.
Okay, that's okay. So guys, here's the reality. Okay, the government acted too quickly. I know not from protecting the health of our people, but the financial wherewithal of our people. The banks aren't ready to do this. Bank of America told us we can start applying, but they're not going to be ready to do it till the mid part of next week. They are going to be inundated with these files. And so I highly recommend you go with a bank that you already have a relationship with. The way it looks, banks are putting clients first and then outside people second. I don't know what to tell you on the Chase deal. They will ultimately do them, but what they're actually being transparent. They're not lying like most of the other lenders. Most of the lenders are not ready to accept these applications yet.
Makes sense. This question, secured loan versus unsecured loan. I'm not sure what
so I know what that's about. So I think the question is whether you can do a secured loan or unsecured loan if you either have exercised the capital call option or it wasn't fruitful. Well, if you do a secured loan, you're going to violate your loan on your due on sale provisions with your loan docs instantly. If you're doing a secured loan in real estate, I don't know what lender is going to accept a secured loan without filing a lien on it. And that lien would be a public record. So you're going to get yourself into very big trouble if it's a secured loan. Now, if you want to secure it by equity, which is way below the lender, that's fine, so long as it doesn't breach any of your equity requirements where, you know, it may be where one person can't have more than 40% or 20%. You know, you'd have to go back and look at your loan docs. And again, this is why you would have a lawyer go through this with you. But I would try to discourage you from doing a secured loan.
Okay. We need some more questions.
So yeah, guys, I'll give you like another, 3 or 4 minutes. And I just, this is going to change regularly. So one of the things, we used to do our Tuesdays with the teams, and it was fun because I was buying everybody drinks and food. Guess what? I'm not doing that now. But we can joke around and kind of have, we did a firm happy hour 2 days ago. And so we can do a Tuesday, quote unquote, with the team's happy hour where we kind of, there you go, you bring your own alcohol, but we'll open it up for questions you guys have that are relating to this. I know it's not normal for lawyers to kind of talk about this type of stuff. I'm going to say it's for informational and educational purposes only, but you guys already know how I am. We truly do want to help you guys. We're in this with you guys. Business will come back, okay? I'm not lying to you. I'm applying for the same loans. I'm right there with you guys. But business is going to come back, and whether it's as good as it was before, listen, if we have 80% more people working tomorrow than we do today, we're all in a much different position. So I'm going to talk to Jeff and see if we can do just like an hour, maybe on Tuesdays or Thursdays. It seems like every day right now is Monday. It's like Groundhog Day. We should call it Groundhog Day with the team. But I'd like to open it up because I'm getting so many questions, and Sandra getting so many questions on social media and email, and you guys are all asking the same questions. Do not be afraid to ask us questions. Like if we do the next one, let's say we do it in a week or next Tuesday, please don't be afraid to ask questions. None of them are stupid. I guarantee you there's 30 or 40 other people online that were thinking the exact same thing. And guys, if we don't know the answer, we'll research it and find it out for you, because if we don't know the answer, it's probably something we wanted to know anyway. And anybody that wants to email me, Scotch, that would be great.
A few more questions came up. We want to take some more.
Yep.
Does it make sense to go to 2 different banks where we have a relationship already and wait to see who submits the PPP app first, or is that going to create trouble if they both submit it?
I think it's going to create trouble. I think it ultimately goes through a database and then goes back to the bank. So I think someone would run the risk of not being submitted. And listen, I know some of you on here listened to Wheelwright last night, or it was last night or the night, but it was last night. I listened to the video conversation. He's a CPA firm, and Wealthability, I think is what the name of the company is. Very knowledgeable guy. and he made some good points about the $369 billion for the PPP. That sounds like a lot of money for you guys, right? $369 billion. So it's interesting. You need to read the fine print. There's a lot of fine print in the 800 and whatever 8 pages or 80 pages. But it's for employers of 500 people or less. Franchises are included in that. So guys, think about how many McDonald's, Subways, racetracks, Burger Kings, Papa John's, or Domino's, whatever. Think about how many of those stores are out there. Every single one of them, in theory, can get up to $2 million if they can. Now, most of those don't have $2 million in payroll and expenses over a 2.5 month period. They have already prepared their applications. That was done by the franchisor, because the franchisor is making sure everybody gets what's entitled to them. So when I say it's important to go and file these, there's a likelihood that they could run out of money in the first week or two. Now, doesn't mean they're not going to put more money into it, but it's not just us on the call that are looking at these deals. Think about all the small businesses, and then when you look at something like McDonald's or Burger King or gas stations, anything that's a franchise, it's tens and tens of thousands of businesses all wanting to do the same thing. So try to get them in as soon as you can.
Okay, back to the idle question. What are the downsides of idle? I heard several issues. It's not just a freebie with no strings attached, right? Please answer in terms of the 10,000 and follow-up loan.
Yeah, so the 10,000, my understanding, is a grant provided you abide by the requirements. It's just okay, so here's the deal. You can apply for just the 10,000, okay? But most of us here, okay, don't need the $10,000. I mean, I don't mean it in a negative way. Like if I'm applying for a loan, I need a couple 100,000. 10,000 is just going to piss me off. So the 10,000 is a grant. Someone's laughing, pissed me off. But the 10,000 is basically, it's a grant. So what you guys want to make sure is, if you're going to go down the route of the idle, okay, you are going to sign your life away like you would on a normal SBA loan pre-protocol, okay? It is going to be a secured loan with personal guarantees. Just keep in mind today, now that doesn't bother me because we have a line of credit with Bank of America for our law firm. And of course I had to sign a personal guarantee on it. But some people are very risk adverse. A lot of us got into syndications because there are no personal guarantees. And just bad boy guarantees, and none of us are bad boys and bad girls, so we don't worry about it. But read, if anybody has questions, they can email me at mcallister@callisterlaw.com. I can send you a couple summaries I've got from some good CPA firms, including our firm that we use, and a lot of you guys use them as well. I went in detail with our controller over idle this morning, and I'll be honest with you guys, it's 50-50 whether I actually like it or not. It's essentially a 10-year loan at, I think the interest rate is like 3.35 right now, but it's recourse. And be careful what you ask for. It's a business line, guys. At the end of the day, it's a business line. If you've taken out business lines before, shouldn't be an issue. If you've never taken out a business line, it's going to scare the shit out of you, because you're going to sign away your wife, your dog, which you may want to sign away both of, your kids, because we've all been living with them for 18 days, but you're going to sign away everything. They may even ask for a second on your house. I'm not kidding. So that's not a gimme. So just keep in mind, that's not a gimme. Now there's a I think it's called an ERC loan. That's a subsegment of that where I'm going to mess it up because I don't know all the information, but something to the effect that if you can show your, let's see, if you can show same quarter last year is 100% higher than this quarter this year, there's a provision there that's very, very cloudy, that says, you can cover that loan with payroll and potentially have a forbearance of having to pay that back up to 12/31. I don't know who qualifies for it. I was told by the CPA firm I don't qualify for it. One thing also, guys, to look at, not many people have, I assume most people here are Texas. There may be some that aren't Texas, but those of you in Texas, Texas Workforce Commission. if you do have small businesses, property management, whatever, Texas Workforce Commission is kind of interesting. So we're still trying to get, we filed it without actually knowing the final answer because it's taking them 4 or 5 days to respond to emails and phone calls. Shocking. But our understanding is that if I, in theory, reduce my salaries to my employees by 25%, but I require them to still work the same number of hours, they qualify for a kind of a supplemental, it's not even unemployment, it's a reimbursement or coverage of the lost income. So I could not find anywhere, we couldn't find anywhere a cap on the dollar amount, but it's not something that we have to pay back as a business. Now we do pay back because our unemployment tax will go up, but in the general scheme of things, going up 15, 20 basis points, which is a minor expense in the first place, is irrelevant. But I would suggest some of you guys look into the TWC. It's on their site. It's like I can't remember exactly what it's called, like an employee compensation or something like that, but you do have to send out letters to your employees stating that that's going to happen if you're going to accept it. And you can't fire anybody or terminate anybody while they're doing it. The idea for the Texas Workforce Commission is we don't have to pay full unemployment claims.
Next. Ready for another one? Okay. What protections should KPs start putting in place?
So KPs are, that's a broad definition of a KP. So some KPs don't have any equity in the deal and just signed on the loans, but they signed on the loans as just financial wherewithal. They don't really have any personal liability. Other KPs have money in the deal. And then some KPs are not really KPs. They're actually part of the manager because they were given some of the manager's interest. So if you're a KP that has a % of manager's interest, you're just as liable as any other manager is, and you're liable for 100% of any liability. It's joint and severable, which means if I have 5 people that are in the manager company and they all have different %, and I want to go after the manager for $1 million, I don't have to prorate who I'm going after. I can go after any one of them or all of them for $1 million. As long as I get my $1 million collected from one or all, it doesn't matter. So KPs need to understand whether they are part of the manager, number one. If they are, they've got additional liability. If they're not part of the manager, I haven't seen anything in forbearance agreements that require the KP to sign off. Listen, the banks aren't stupid. They know the KPs aren't going to put more money into the deal if they've already put money. And if they were going to put more money in the deal, you would have already done a capital call. I'm going to, again, guys, do not go to a forbearance agreement unless you've exercised capital call and or an unsecured loan.
Okay, any concerns that tenants recognize some power and do a collective rent strike if the job rehires or businesses don't come back very quickly?
Who asked that? Don't say.
Are we
Don't
staying
say.
anonymous?
No. So I need to go take a Xanax now. Yes, I have the same exact concerns as every single one of you. And yes, I followed this movement that started in California that's got like 14 million followers now of we don't have to pay rent. And as long as it stays in California, I don't give a shit, but it's not. That's kind of why, yes, to answer the question, short answer, yes, I have concerns. That's why I posted today on our private page. Anybody that wanted to share kind of how their collections were going, I was very pleasantly, I don't know if surprised is the right word, maybe reassured that our tenants do want to pay rent if they can pay rent. And they do understand if they don't pay rent now, they're going to pay it later. So yes, I have concerns about that. That goes back to communication with the tenants. And guys, I'm not talking as a lawyer, I'm talking as a syndicator like you guys. You already know it. You're never going to get in trouble with communicating with everybody, and don't piss them off. Don't chastise them if they're laid off. Most of them did not want to be laid off. This was not a choice that any of us or them had. Everybody's
Okay,
drinking.
I think we're going to do one last question and then schedule a Q&A next week. So last question.
$500 an hour.
Can you please list a couple of unsecured loan types that we can look in?
Cindy, I apologize. You broke up.
She might be having audio problems. So can you list a couple of unsecured loan types that we can look into before cash calls or forbearance?
Yeah. So guys, it's I think I probably made it more complicated than I should have. So I'm an investor in Kevin's fund, and Kevin comes to me and says, "Hey, listen, we don't want to do a capital call right now. Would you be interested in doing a $200,000 unsecured loan?" Sure. Kevin and I, we go to a lawyer, and the lawyer drafts just a simple promissory note. That promissory note says the fund promises to pay I promise to pay the fund $200,000 in exchange for 4 or 5% interest over the next 4 years, 5 years, whatever, until I get my capital back. It should be somewhere in that interest rate. It needs to be at a market interest rate, especially if you're an investor or you're going to have a world of hurt with other investors. So just keep in mind, an unsecured loan simply means there's no collateral. That's all it is. Thanks, Kevin.
All right, thanks, Merrill. I think we'll start to wrap it up. Everybody will be provided with a downloadable copy of this presentation tomorrow. We will also post the recorded version of this. As well, everyone who's registered for this webinar will be signed up for an open Q&A call that we will schedule for sometime next week.
Everybody be safe out there. And just put up with your wives. That's all I can say. And if you're a woman online, put up with your husbands. Cindy does practice family law. And so I know people have been saying that they think there are a lot of babies that are going to be born in January and February. I'm betting on more divorces than babies. So we are a full service firm.
Yes.
I'm kidding. But seriously, everybody be safe. And I think we're going to try to explore this happy hour next week if you guys are interested. And, submit questions in advance. And we'll go from there. Thank you, guys.